Okay, for this second section, we're looking at a couple of parts of international law, which is the actors in international law, and also what's meant by jurisdiction. So let's firstly look at actors in public international law. So firstly, in terms of actors, what we're talking about here is the concept of legal personality, how the law sees that thing as a person. Now, the idea of personality or a legal person isn't the same as a human, because non-humans can have legal personality. So, and that's shown that in terms of public international law, the primary actors are states. States themselves have a legal personality. It means they have various rights and duties. And that's different to domestic law, where people themselves tend to be the primary actors. Of course, they're not the only actors, but they are the main actors. So criminal law is a law over people, for example. Now, in international law, the primary actors are going to be states. That means that states have various rights and duties. And this has been identified and kind of established since what's known as the Montevideo Treaty on Rights and Duties of States. Montevideo is in Latin America. And according to this treaty, this kind of establishes what a state is. We're not going to go into that in too much detail. Some of you may know that there are these four kind of criteria which is necessary to be a state. So obviously Thailand, is a state, but Bangkok is not. Now that means that if you're a state and if you fit that agreement, if you have recognized as a state, you have certain rights and duties. And this is important in terms of human rights, because human rights for states, they've got duties towards human rights, but they've also got certain rights about what they do in terms of interpretation or agreement with human rights standards. Now, states are not the only legal personality in terms of international law, particularly around human rights, because there are many other non-state actors that have some form of legal personality. That can be, intergovernmental organizations like the UN or the World Bank or the IMF or the Asia Development Bank or the Red Cross and so on. It can be companies, so companies also have legal personality. They can sue and be sued, they can own property and so on. International NGOs can also have legal personality, and even non-state armed groups, for example, or armed groups as well, have legal personality because they have certain duties and obligations in terms of the laws of armed conflict. But also importantly, that you have, people themselves are legal personalities in public international law. Because some international law, is power over people around things like, say, the crime of genocide, in terms of human rights, and so on. But even other things like animals and ecosystems may have legal personality as well. So the important thing here is that states are the main actors in public international law, and they have rights and duties, as do people and as do some other objects as well. Now the next concept, actually before we go to the next concept, this is just looking at the ratification of the Montevideo Convention in 1934, where it was established that to be a state, you have to have territorial integrity, you have to be recognized by a state, by other countries, you've got to have a permanent population, and you've got to have a functioning government to be a state. So this is important in terms of debates around self-determination as well. Now looking at the next concept of jurisdiction. Jurisdiction literally means where the law, the juris, has power or diction, or where it speaks. Juris, the law, diction, to speak or to have power. Now, all human rights treaties have territorial jurisdiction. They end at the borders of the country. So you can see in the map here, like Thailand, Thai human rights end at the border. You step over the border from Thailand to Cambodia, you have different human rights. You have human rights according to the Cambodian government. So most treaties that they ratify are based on territorial jurisdiction. And not all the rights are territorial, but the bulk of them are. The treaty itself is mainly territorial. Now, some treaties have some jurisdiction which is called universal. This means that that country sees that law is operating anywhere. This is, for example, over trafficking and torture and slavery, that country would see that there is universal jurisdiction. That is, that Thailand would see the crime of torture as a crime no matter where it occurred, anywhere in the world, whether it's China, Philippines, Indonesia, Malaysia. Thailand sees that as a crime. It's not based on territorial jurisdiction. If you rob a bank, Thailand only sees that as a crime for Thailand if you rob a bank in Thailand. If you rob a bank in Cambodia, that's a crime in Cambodia, not in Thailand. But if you commit torture in Cambodia, that's a crime in Thailand and Philippines and Indonesia and so on, or it's a crime in those countries that see that they have universal jurisdiction, which defines torture as a crime no matter where it occurs. Okay, so universal jurisdiction can be quite a powerful law against things like torture and war crimes and so on. Now, the last type of jurisdiction then is called extraterritorial jurisdiction, or what's more commonly now called extraterritorial obligations. Now, this occurs a couple of different ways. Now, sometimes states have laws over their citizens, no matter where those citizens are. So, for example, you have citizens' rights in terms of voting. Some countries recognize that. If you're a Thai citizen and you're overseas, you still have the right to vote, no matter where you are. It doesn't depend on the territorial jurisdiction. So some rights are based on the person and not on the country, not on the territory. Now, and there are other crimes that have extraterritorial jurisdiction as well. So particularly around things like, say, drug trafficking. Some countries say that if you're a drug trafficker, that's a crime in our country no matter what. Okay, so it can be, extraterritorial jurisdiction over some subject matters. And the last one is that this is the kind of the developing area in terms of jurisdiction is called ETOs, extraterritorial obligations. And this is one way to look at trying to enforce accountability in the business community. So transnational corporations operate in a number of states. They're trying to enforce extraterritorial obligations. So if you're a Japanese company, it doesn't matter where you're working, that the people who work for your company or the impact that what your company may have is still going to can be tested under Japanese law if you're a Japanese company. Now that's not the case, but this is what they want. They're saying that if you're a company and a Thai company, no matter where you act, you should still have obligations of enforcing human rights. And this has occurred a bit in Thailand with Thai companies building dams or taking over sugar plantations in Cambodia. That parts of Thailand and the Thai justice system have tried to enforce those companies' standards around human rights. It's still a developing area. It's not strong, but it's one area which is developing around business accountability. Okay, and that ends this section.